was carrying on in my payroll area. He was changing time records, he was overpaying people, he was underpaying people, and after he decided to leave, he decided to come after me. I was hit with what's called an FLSA lawsuit. It's a federal lawsuit. It does not matter if you have a corporation. They can go right through it and sue you personally, which they did. They sued not only me, but my 92-year-old father. We settled the lawsuit rather than going to litigation. My first attorney really didn't respond all that well, and the opposing attorney, who has 114 cases on the books in Illinois alone, is predatory. He goes after small businesses, small dry cleaners, mom and pops. And we found out exactly how wrong our record keeping was when we thought it was airtight. Our employees clocked in, they clocked out. We used Party Center for clocking in and out. Party Center doesn't allow you to set any parameters as to when people can log in and log out. So they would clock in, the kids show up at your rink that work for you, they clock in 40 minutes early, go hang out with their friends, because they knew that we paid 15 minutes before a session until we were done. Can't do that. If you're not paying your employees down to the minute that they're clocked in, you're not in compliance. If I had known the information that I know now, it never would have happened. And the end settlement was more than my annual payroll. So whether you have 1 employee, 5 employees, we usually have a roster of about 30. Over the 25 years that I had my rink, we employed 154 people. And they're currently probably all going to get some money out of this settlement. So it was excruciating. It was 2 years of my life, coming up with records, trying to find old records, trying to figure out what went on. We didn't realize the depths of it until we got into it. When my first attorney decided to remove himself with no notice, another attorney friend said, "I'm going to try to help you." He helped me gather all the information, which, oh my gosh, we submitted over 5,000 records, and it didn't matter. Your employees do not have to prove anything. All they have to do is say, "I don't think I was paid enough." My second attorney, who is a dear friend, met our speaker, Chuck Krugel, said, "I think this guy can help bring this to a close." All Chuck does is represent employers. He's in Chicago. He did an amazing job of pulling it all together, and so many conversations we had where I wish I had gotten into this sooner, it wouldn't have been as bad as it is. But he's going to be speaking to you today about how to protect you and your family and your assets and your rink. I didn't sell my rink because of it, but it was a mitigating factor in the decision to sell it when an offer came in. Chuck's become a friend. He was there every step of the way through this whole thing. And I asked him to talk to you because the gift that I can give you as I leave after 25 years in the RSA, not knowing there was a retired membership, so you'll still see me around, is to help you protect what you've worked so hard for. How to make sure that you have the systems in place so your employees, and it only takes one disgruntled employee to trigger one of these things, that you can protect yourselves. So our speaker this morning is Mr. Chuck Krugel, and I'll turn the mic over to him.
Want to get the
Yes.
Thank you, Sandy. Appreciate it. Thanks for having me here. Glad to be here in front of you. I came down last night and got to meet a lot of you, and one of the things I first noticed was there's a great deal of intensity regarding the operation of your businesses, largely because a lot of them are family-owned. They're closely held businesses, husbands and wives, siblings, parents and kids. So it's pretty cool to see. I grew up myself in that type of environment. My dad owned drugstores in Chicago, with youth partners, and one of the things I learned from him and from family members in their industry, and basically this applies to every industry with family-owned businesses or closely held businesses, is that you always have to have an operator or an owner on site to watch over everything, to make sure that the inmates aren't running the asylum, or the inmates aren't running the asylum or prison, so to speak. So that's one of the lessons that was, clear in this case. Another thing, just to point out to clarify, is that it's not just federal law. Federal law is kind of the umbrella over this, the Fair Labor Standards Act, but we're also dealing with state and local laws. On the state level, we have a labyrinthian system of like compensation and benefit laws, and then minimum wage laws at state levels too, or at local levels. Like a number of municipalities now are passing their own legislation regarding minimum wages. Chicago, Seattle. So you have those. You have that extra level too. So you have state, federal, and local levels to all of this. Also, feel free to ask questions anytime. Some of the stuff gets pretty complicated, and if I'm talking in legalese over your heads, it's just going to be really boring, and it's just going to be hard for everybody to get through. So ask questions if you want. Don't hesitate to interrupt me. You want me to focus on something, or if you want me to repeat something, I'm happy to do that too. The handout's general information regarding a lot of this stuff. I'm going to talk mostly about the case. I can't get too in-depth into the case because it's a settlement and it's confidential. I'm going to be in court this Thursday to finalize a lot of stuff. It's in federal court, but the federal court also oversees the state laws that we're dealing with. So it's about 3 or 4 different laws that we were dealing with. Also, you have different statutes of limitations. So for example, the federal law, which is the Fair Labor Standards Act, you could go back 3 years. But in Illinois, under the Illinois Wage Payment and Collection Act, you could go back 10 years. Now, I don't know of any other state that's like that. We could go back 10 years. I'm doing some work right now on behalf of another client in another industry in California, and that's only 3 years. And they say that California is the most liberal state when it comes to employment, but I've never seen anything that touches upon the 10 years in Illinois law. So, make your own assumptions about who's more liberal or not. The Illinois statutes seem to be much more liberal, in my opinion, than the California statutes do. This case was unusual because, like Sandy said, I'm the third attorney to get involved in it. Usually I don't like to do cleanup or armchair quarterbacking for other attorneys. I like to get in at the ground floor, but I do like challenges. When I heard about the opposing counsel on this case and what was going on with him and his record of litigation in this and the general nature of these cases, which I'll start getting into them in a couple seconds. But when that was part of the challenge for me was, wrapping this up. And again, also since it's a family-owned or closely held business, that was kind of interesting too, since that's where I grew up myself. What you have going on in this sort of industry now with this wage and hour, minimum wage, overtime, unpaid hours sort of industry is there's a lot of predatory attorneys out there that specialize in this. A lot of this started in 2000, or in the aftermath of the economic collapse of 2008. So what happened was you had this double whammy of but all government agencies at the federal, state, and local levels who were hungry for tax revenues. So they were going after businesses to try to collect on unpaid wages, unpaid payroll taxes, unemployment compensation taxes, things like that. And then you had the attorneys themselves recognizing that this is a great opportunity for us because we could go after these companies, whether they're publicly held or privately held or not-for-profits even, and we could collect the statutes allow you to collect attorney's fees. That's a mandatory part of the statutes. There's also what's called liquidated damages, which is basically double the amount of unpaid overtime, unpaid minimum wages, unpaid benefit time, whatever. So you have the liquidated damages, the statutory damages. In some cases, there's potential for punitive damages, which is above and beyond all the other damages. And punitive damages are intended to send a message to businesses and the owners of those businesses that what you did is wrong, and therefore we're going to punish you even further than unpaid wages and the liquidated damages and the attorney's fees. However, in a lot of these cases, the attorney's fees end up way eclipsing the unpaid minimum wages and overtime. A lot of time it's not the overtime and the minimum and unpaid minimum wages that's the problem. It's the attorney's fees themselves. I mean, these guys, and like I said, these are predatory attorneys. They recognize the opportunity in the aftermath of 2008. And now what's happened is that you have a lot of these, like what are called workers' associations and labor unions, which are helping to stir up the pot. They're trying to get members for themselves or organize businesses, and it's created a feeding line for these predatory attorneys and these other regulatory agencies, such as the Internal Revenue Service or the U.S. Department of Labor. That's on the federal level. On the state level here in Illinois, there's the Illinois Department of Revenue, the Illinois Department of Labor, and the Illinois Department of Employment Security. So that's 5 different agencies that deal with that. And then on this local levels, like if you're in Chicago, you have the Cook County Commission on Human Rights, or the Chicago Commission on Human Rights, which and the Chicago Department of Revenue, which may or may not decide to get themselves involved in this. Whether or not an agency gets themselves involved in these types of issues, a lot of it depends on their manpower, their ability to handle the overhead of trying to get involved in this. And a lot of these agencies would rather just defer to the state or the federal agencies to go after the businesses. So that's sort of what, it's sort of the dynamic, the larger dynamic that's at play here. You also have the actual litigation process itself, which is a nightmare for businesses. You have to produce thousands of pages of records. In Sandy's case, I think she mentioned 5,000. It may well have been that. Another case I'm dealing with right now, we got 3,000 pages of documents. And these are time cards. You have time cards, you have different receipts. Some of it's handwritten, some of it's created by payroll companies. Some of it's just, from a point of sale or a point of system, like sort of operation where they punch in and punch out. And it's a whole myriad of records and things like that. And it becomes really difficult to try to assemble this and assimilate it all into a coherent story for the court or for the agencies themselves. But that's sort of what my role is, or try to do, is to assemble all those records into a coherent story and explain why the mistakes that were made, they were made in good faith. And, there was no malice intended. It wasn't intended to be theft or anything like that. And why they were maybe what's called, the legalese is called de minimis. They were minimal exceptions, so that maybe somebody punched in 3 or 4 minutes late, somebody punched in 3 or 4 minutes early, and they weren't paid for those 3 or 4 minutes. They were just paid then for their regular start time. Or somebody may have punched out late, 10 minutes late, and wasn't paid for those 10 minutes. They were just paid until their recorded end time. So you have those types of issues. You also have issues involving salaried versus non-salaried or hourly employees. So salaried employees get like a base sort of wage or base salary per a defined pay period, and they don't get overtime. They're exempt from overtime. Whereas hourly employees are what's called non-exempt. They're supposed to get overtime, which is generally time and a half, but some states like California, on the weekends, they allow for double time. And then there's all these different things, like which rate of pay applies. If there's if it's overtime, then does overtime apply to every hour over 8 hours in a day, or every hour over 40 hours in a week? Some states or localities are different depending on how they operate. Besides the fact that you may have a 10-year statute of limitations on the state law, but a 3-year statute of limitations on the federal law. The state law might not allow for a class action claim, but the federal law allows for a class action claim. And what happens in the class action is that the lawyers, the predatory attorneys I'm discussing, the opposing counsel, they're allowed to delve into your records and see everybody who's worked for you for the past number, generally 3 years. But for our case, we went back 10 years because we just wanted to make sure that everything was sealed off and that there were no other claims out there that anybody else could bring through another attorney or another agency. So it's just this whole mixed up labyrinthian system of laws and regulations that apply to this industry. Every industry. Your industry in general. I think my own opinion is that if you're in an urban center, you're more likely to get hit by this than if you're in a rural sort of center. However, even if you have rural skate rinks, you could get hit if you also own urban centers, because what happens is that the attorneys or the agencies are going to want to know what else is out there, what other businesses you have, similar, not every business that you have, but what other similar businesses you have that we can basically pilfer from to get at the money. Besides going after personal assets, these laws, generally on the state and also on the federal level, it permits you to pierce the corporate veil, that's the legalese, to basically go after the personal assets of the business owners. Sometimes you can get insurance for this stuff. However, generally speaking, directors and officers or general commercial liability insurance and employment practices liability insurance usually doesn't cover these types of cases. Now, why is kind of, I don't completely understand this, but the research I've done is that these cases are considered theft of wages, and insurance companies won't cover theft, which is like a criminal act, and they're just not going to, they don't condone that, so they're not going to cover it. but you can't get additional riders, is my understanding, or clauses that will cover these types of cases. But you still may have to pay, you may still be on the hook for attorney's fees, especially the other side's fees, depending on what the insurance itself covers. So there's always these different factors that you have to look at relative to the insurance, those types of issues. You also have to look at your payroll company. I mean, a lot of you may use third-party payroll companies or might use a software such like Quicken or QuickBooks, something like that. You got to do your due diligence and figure out, is this going to allow me to properly record overtime, straight time, and any other types of salary time or premium times that you have. So you have to make sure that your payroll company can handle this. In Sandy's case, there were 3 different payroll companies in about a 10-year or so period, and that was part of the problem, was that we're trying to match up records from different companies, and these aren't they're not all the time congruent with one another. And that's also problematic. Your records have to be comprehensible. They have to be comprehensible. They got to be easy to read. I mean, none of this should take a rocket scientist. What I do is not rocket science. And if it's more complicated than it should be, that's a real problem. So, that's a lot of what this comes down to relative to the payroll recording, overtime recording, payroll processing, administration, that type of stuff. Your own business administration. Any questions at this point or comments about this? Yeah, thanks.
Going on the same vein here, but a little bit. What when you have 2 companies with common ownership?
Yeah.
There are 2 completely separate operating entities with different physical addresses. But you have an employee who may work at both entities. In a given week, their accumulated hours between the 2 entities would normally cross that threshold into the overtime premium pay. But yet they're working 2 separate facilities, 2 separate entities, working hours at those facilities, being with a separate payroll, everything. Is there potential liability because there's common ownership and having a common employee working in both entities and going into an overtime premium hourly threshold in a weekly basis?
Good question. And the short answer is yes, there is. You have to look at the overall circumstances. So the reality, it's called in legalese the reality of the circumstances, as opposed to what's on paper controls. So if there's common ownership, there's common ownership on paper, officially speaking, and then if the owners themselves are moving back and forth between the 2 businesses, employees are moving back and forth between the 2 businesses, it's held, the public knows that, maybe the parents of the employees know that they're working at both businesses. The parents and the public themselves know that it's common ownership, even though they might be different names, and even though at the Secretary of State's office, whatever, that they're under different corporate entities, that might not matter. What's on paper, it's going to be the reality of the circumstances usually that's going to control. So yeah, that's why there might be a joint liability there or you might have to look at how much they're working at both places as opposed to each individual entity.
So following that same vein, then, who becomes responsible for the premium pay?
One of the businesses.
One of the businesses.
Yeah.
With no entity. I mean, what is the definition? Who's going to be?
Well, you're going to have to figure that out. Otherwise, the agency, the regulatory agency, or the predatory attorney is going to figure it out for you. They're going to go after whoever has the most money. That's why they went. That's why Sandy's father was involved in this, because he has money. I mean, they're going to. If I don't figure it out for you or help you figure it out for you, somebody else, a third party, is going to figure it out for you. And anytime you get a third party making business decisions on your behalf, you're in trouble, because they're not going to care. They're not going to care about a sob story. My mom's in a nursing home or something like that, or they're not going to care how many kids you've helped educate and put through college or high school, whatever. They're just not going to care about that, and they're going to make that decision for you then, and it's going to be based on who has the most money.
Again, I'm going to follow the same vein here, because I want to take it now, figure out as a business owner who has those scenarios where you have common ownership and common entities and common employees, where within the state structure or statutes can we research to find that information? If I just leave it to open-ended and I'm going to try to wait for the court system to decide, I mean, there's got to be some law that's written or regulatory procedure that where do I go research this information to find that, to see if my state has an issue with that practice. If you
From a
will.
layperson standpoint, the answer to that is the closest thing that in my industry is to rocket science. It's very difficult. You search online and you might find like 3, 4, 5 different laws, and you got to read through these laws and see where they overlap with one another, where one will provide for maybe punitive damages and one doesn't, or one provides to, the opportunity to pierce the corporate veil and one doesn't. And it's very difficult. As an attorney myself, I've been doing this for 24 years and almost 18 years on my own now, I have trouble with this stuff myself. I can't remember off the top of my head all the layers and all the little nitty-gritty stuff, the micro aspects of these laws. It's really difficult. Plus, I mean, honestly, in Illinois, and I deal with other states' laws too, like California, and I've done business in New York and Florida, Wisconsin, Indiana. Illinois has really poorly written laws. It's out there, and everybody knows it. We have poorly written laws. This whole 10-year part of it, of the statute I was talking about, that's not in the main part of the law. That's its own separate little law in a separate paragraph that's out there, hanging out there. You might not even know where to find it. Usually, off the top of my head, I forget that law even exists, unless I'm actually confronted with it like I was in this case. So, yeah, I mean, it's this bizarre labyrinthine system that really works against business, in my opinion, works against business owners, and has been, a lot of these laws are sort of ancient, so to speak, or in the context of our legal system. The Fair Labor Standards Act was enacted in 1938, so it's 80 years ago now. Some of these other laws were enacted in the 70s or 80s, so that's a little bit more modern. But a lot of them don't take into account the changes in technology, how we operate technologically speaking now, things like that. So, yeah.
Just what I know now, you are now aware that a close personal friend of yours has a fuzzy situation. Get rid of it. You're at risk. Get rid of the fuzzy situation.
Yeah, it's.
I don't buy that. There's got to be some legal protectionism. I mean, I understand what you're saying.
Fine.
But if I have a corporate entity and it's supposed to be protected as a living, breathing entity on its own, so my guess is that the first objective is to pierce the corporate veil will be the first objective. Once they've broken that and pierced that veil, then you've got all these floodgates open.
Yeah, but the law provides for piercing of the corporate veil explicitly. See, you're thinking that they might. I think where you're coming from is that they might pierce the corporate veil as a strategy. It's not necessarily. It's a strategy because the law permits it. The law says you can pierce it. Otherwise, you have to rely on legal doctrines through case law or other theories
right.
to do that.
But the first step is they have to prevail, piercing the veil first. They have to prevail within that argument.
No, they have to show that there's actual unpaid time and wages. I mean, the idea is not. You have to realize too that in a lot of these cases, a lot of the unpaid time or compensation we're talking about is not a lot of money. It could end up being like, in one case I'm dealing with, it's like maybe $50 for 4 employees right now. That's not what we're worried about. What we're worried about is the attorney's fees and what the attorneys are going to do. So the attorney, right now, no loss. In this other case I'm dealing with, and I got it, and this is the difference, comparing this other case to Sandy's case, I got involved in this case on the front end. There's a client I've had for like 10 years now, and I've been successful with them in other states. So, they rely on me for this stuff. And I got we got a letter from a predatory law firm out in another state on the West Coast, and what they're saying, you've not paid your employees properly. They're supposed to get multiple pay rates for different projects, and you haven't been doing that. So now what happens is, my client's like, all right, we've been doing this right. I know we've been doing this right, and they're great people. I mean, there's no doubt that none of this is intentional. They start researching this, and it's like, oh man, they found some violations. They found some problems. So now what they got to do is go back to those attorneys and explain to them, we found problems and violations, and we're going to pay our people. And the idea is not, and it's what I'd like to call like a fall on your sword defense. We're going to own up to this and admit it. First of all, in litigation, there aren't really many secrets at all. The whole idea of civil litigation and what's called the discovery process, basically when you exchange documents and have depositions and that type of stuff. The whole idea of this is to basically bring everything out to the forefront so the court can, figure out what the key issues are and then make a reasonable decision, or have a jury make a reasoned decision based on what the facts are. You're trying to discover what the facts of the case are. Well, the facts of the case, this other case I'm dealing with where I get involved from day one is not so much that we owe a lot of money to employees, it's what are the other attorneys going to do. And so there's been no agency complaint filed yet and no lawsuit filed yet. So we're playing a game of cat and mouse with one another, and we're owning up. We've discovered these mistakes as we go along, and we're owning up to them. And then they want to know, well, let's do this form of alternative dispute resolution where we go before a negotiator or something like that. I don't want to get too technical because we're in the process of this, and I don't want to say anything that's going to divulge their identity or the identity of anybody else in this. But so we play this game of cat and mouse. My response is going to end up being, I'm not going to recommend that until we know how much money you want. Because the amount of money that they want, ultimately it could be just, like I said, a very small percentage of it is going to be the unpaid wages. The larger percentage of it is going to be their attorney's fees. I don't have to worry about liquidated damages, punitive damages, or anything like that yet, because no complaint or no lawsuit's been filed. And that's sort of what you're dealing with. Usually the way these start, and I'm pretty sure it started with the same way with you, is that you get a letter from the attorney, from the opposing counsel saying, we believe all these violations have gone on. Let's go
I
even
didn't
further
even
back.
get that, Chuck. What I got was a letter asking for an employee's file that had left. I had 9 girls leave for college at the same time. She wrote me back in right before the fall and said, hey, can I come work for you in the summer? Or can I work for you during winter break? And I said, I'm sorry, but when 9 of you guys left, we hired new people and trained them, and I can't drop you in the middle of a trained team that's used to working. We've made changes since you worked for us. Well, that's what started all this. Then apparently she sent a text to one of my other employees, Sandy's lying, they just don't want me to come back. I didn't know I was fired. No, you all quit when you went to college. She took the stance that she was fired with no notice, that she would have been allowed to come back at any time. So all I got before the lawsuit was a letter from this attorney asking for her employee file. Okay, she's gone. I figured they needed it for college or something.
So Sandy, the letter stating that it's a wrongful termination.
No, never stated anything.
Yeah,
All it said is, I'm attorney for so-and-so. I'd like a copy of her personnel file.
and this is why these are problematic, and maybe I could tie in a couple of these loose ends here. It doesn't matter if she's claiming wrongful discharge in Illinois, because in Illinois there is no such thing as wrongful discharge, the tort of wrongful discharge. We're an at-will state, so you could be fired for any time, any reason. But the problem is, you start looking at the records, and the records themselves, if they're not, if they don't make sense, and you're finding discrepancies in timekeeping and things like that, that opens up a whole different can of worms. You're not talking about discrimination or wrongful termination then, you're talking about payroll violations then.
And I didn't include any payroll information. It was strictly her application, any disciplinary issues that we keep on file. There was no payroll records at that point.
And also, usually...
What does she have to even supply that? Would she even have to give that information on?
Generally speaking, you usually only have to provide the hours worked. It's got to be like on a check stub, like the hours worked and a breakdown of the overtime earned, vacation earned, sick time earned, whatever. But what happens is, we all know that sometimes there's bad actors out there in business, and they manipulate the actual foundation of those pay stubs, the actual records that go into producing those pay stubs, meaning the time cards, sign-in sheets, whatever. And that's really what the companies and these attorneys, these other attorneys go after, are those hard copy, or sort of like hard copy records. Those are the ones that are really the thousands of pages of documents, because those are the ones that lead into what goes into the pay stub explanation, or this more like official explanation that goes to the employees. And what happens is, in these cases, the way they start is, you have one employee talking to another, and they're like, something doesn't seem right, and it's like, well, I know this attorney, I heard about this attorney who does this, let's call them up and let's see what happens. And the attorney, in this case, in Sandy's case, it went to a larger law firm. For whatever reason, the larger law firm referred it to another attorney, another guy himself, a solo practicing attorney, they themselves take a referral fee too from this. So, you know, and then this other guy was dealing with the case. And, you know, he, for about 7 or 8 months, ran roughshod over the first 2 attorneys. Honestly, there were things that I had to do and say, even in front of a judge, that I thought I would never have to say in front of a judge or anybody else in my lifetime. So I actually called the attorney in front of a federal judge. I said, this guy's the most obnoxious, rudest person I've ever dealt with. So, and the judge was just dumbfounded and looked at us like in silence, and, you know, realized that maybe, you know, after 2 attorneys, maybe this guy Krugel was right, you know, and, you know, that there's something more going on here than just, you know, what the defendants are doing. The allegation was that we were, quote unquote, slow walking discovery, that we were not producing documents in a fast enough time period. Well, the problem is that when you're going through thousands of pages of documents through 3 different payroll providers over the course of a number of years, yeah, it's going to be slow and difficult, because you're trying to figure out, you know, you're trying to match up all these different systems and, you know, these different levels of operations and the dollar amounts, and trying to make sense of it all yourself. And if you have trouble making sense of it all yourself as the owner or operator, and as the attorney representing the owner or operator, what's going to happen with either the agency or the judge that you're in front of, or the other attorney. So it can be very difficult, extremely difficult to handle that. Like I said, though, it's not rocket science, but it's more like an accounting sort of exercise.
Back to Danny's original situation.
Sure.
He has something going on here, and I think what he's wanting to know, and it's what I'm curious about. He's wanting to do it right. He's wanting to make sure he's doing it right. He doesn't know where to go to for that answer, right? How does he find out what the right way to do that is?
2 words, and then I'll expand on that. Common sense. You're running a business. You have employees. You want to be preventive and proactive, so you pay your employees on time and accurately. And then you survey them, or you have an open door policy, and you let them come to you, or you go to them and say, hey, are there any problems with your payroll? Maybe you have them sign an acknowledgement along with their checks that, you know, every 6 months or every year or every quarter or something. I haven't seen any problem with my payroll. And not that they're waiving any causes of action, but at this point in time, they're not aware of any problems themselves. And that, you know, you tell them, hey, if you become aware of an issue, you don't go, you know, you can't tell them not to go to an attorney. You can't tell them not to go to the U.S. Department of Labor or State Department of Labor. You can say, look, please come to us first. Let us know so we could rectify the situation.
But none of those people ever did. They thanked me because we had a 10% mandatory service fee. Thank you for sharing that with us. You don't have to. Nobody ever said a thing.
But you were off site, like you said, for a year and a half or so, and that was part of the problem too.
Yes.
You were off site and you're not there, and you had a bad actor helping to run the business. So that was part of the problem. That's why, you know, I say that always an owner or somebody you trust as an operator has to be on site all the time to handle that. You have a question?
In the industry we're in these small businesses, a lot of us are running this payroll on our own. I mean, we have our own payroll system, but like a separate company we work for. But if he's in the office and he's running payroll and he says, yes, they worked 48 hours this week, how does he know what side to put that on? What company side to put that on?
Well, you're going to go with whatever company that they worked for. I mean, whatever site that they worked in. So it's not like I don't think you have like a choice necessarily, like I want to put it under company B because company B had too many, company A had too many hours last quarter and I need to balance this out. It's going to be, you're going to put it where they did the work.
But if they work both companies within that 40 hours, where would you put that?
We do a list.
Are you saying like first in, first out kind of thing?
Yeah, sort of like
It's
that.
like first in. So if the employee works 32 hours at one company and then they work 12 hours at the next company,
Yeah.
in the hours of succession, when they finally hit that 40-hour benchmark,
Where were those
if you will, if that's what it is,
Yes.
when they go over that, they put that at other company. So, and again, I'll follow the same line of lines. What difference does it make if he's working for your company or my company and accumulates more than 40 hours in a work week? Now they have 2 jobs. Now that was where the common ownership question became, and because where does the line of demarcation occur legally? Because I have a common ownership. The other side of this other equation is we're dealing with minors, many cases, and in most states, and certainly in Michigan, they can only work with a school 48 hours. 30-hour student, they get 18 hours of overtime. But a lot of these employees are ambitious, and usually they're good employees, will work more than one job. And they don't tell me I have this other job, or don't tell me how many hours I work this. And they work so many hours this other job, and then they work for me, and they push them over the 48-hour threshold. Where does that liability begin and end in that case?
Well, you sort of answered your own question. If you don't know that they have this other job, and clearly the other job is a different job that's not connected with you, if you have common ownership of two different sites, one site's a roller rink and the other site's a Burger King, then those are two different businesses. So you would apply the hours that they worked overtime, maybe at the Burger King, wouldn't apply to the roller rink. But if you have two roller rinks and they have common ownership, then you would look, then it would be both.
It's more reasonable you would know, and that's where it comes in.
The reality of the
the reasonableness
circumstances.
of knowing and of notification, of notice. The reasonableness of notice.
Reasonableness is an actual legal term that comes up in a lot of these
That's why I
cases.
use it.
Yeah.
And we started, we have this after-school club at 501c3. My employees put hours in at the after-school club, totally separate entity, and the rink. What my accountant set up was a lease program. Orbit leases the employees to the after-school club. When payroll time comes, they upload an invoice into my after-school club that I pay back to the rink. So they get one paycheck. But all the hours are accounted for. That way overtime is covered. If you have the two rinks and they're working between the two rinks, maybe leasing the employees would be an option because that's worked really well.
I'll get to your question in a second, but again, if you're proactive, you're going to pay your people on time, accurately and properly, and if there's an issue that arises, or even if you're not aware of issues, as long as you make yourself available to resolve issues as they arise, as opposed to waiting 6 months or hoping that they don't contact an agency, or in some cases with a bad acting employer, they'll say, if you talk to anybody else about this, I'll can your ass and you'll never work in this industry again, blah, blah, blah. And then, I'll contact your father's company and I'll make sure that they fire you if they have a cause. My brother-in-law is a supervisor or something like that. I mean, that's the type of stuff, to me, you want to avoid. Because, like I said, in litigation, there aren't really any secrets, and this stuff comes out in the wash eventually. And also, the later it comes out in the wash, the later all this stuff comes out, the more money the attorneys make. The more money I make, the more money the other side makes. It's always cheaper to resolve these issues on the front end because there's no lawsuit, there's no complaint yet. You're not talking about punitive damages or attorney's fees or anything else. You're just talking about the unpaid compensation. And like I said earlier, a lot of times the unpaid compensation pales in comparison to the damages and the attorney's fees that are at stake in these cases.
Okay, to this point, all we've talked about is not paying somebody properly for their hours. You have an employee who's scheduled to work from noon till 5. They clock in at noon, they get paid at noon. We pay to the minute, so we're good there. At 5 o'clock, an employee doesn't show up for work, this guy stays over and covers their hours. Where am I in trouble with mandatory breaks? I didn't supply a guy with a break.
It depends on the state. So like in Illinois, I think
We're Illinois.
So in Illinois, and don't quote me on this. I have to, like the disclaimer on the handout, I'm not giving you guys legal advice. I'm not acting as an attorney. But I think the law is that after 5 hours or something like that, at 5 hours you have to give them a break, an unpaid meal break of at least 20 minutes, I believe. I think it's the meal and rest period law is what it comes out to. And so, yeah, there are laws like that provide for a rest break, and then after another 8 hours, after a total of 8 hours, I think you have to give them another break. I don't remember how many minutes it is. It might be less than 20 minutes.
But those are unpaid breaks. They should probably clock out, clock back in.
Exactly.
Most of our workers don't work more than 5 hours in a shift. But every now and then,
We pay them for their breaks. We feed them free.
So
we don't make them clock out. But my fear is you get busy and you forget. Oh, man, Mike's been here for 6 hours. We forgot to give him a break. How on the hook am I for that?
Yeah, I mean, you could end up being completely on the hook because if the time's not being properly recorded,
Right.
it leaks. in that one instance, you have a problem that could lead to inferences of other problems, that, in the larger picture.
Yeah, well, we'll say, hey, go take a break, take your skates off, but it's not documented.
You also have to make sure that you have a policy, and usually, again, I think somebody here, they mentioned worked for the government for a number of years, and how the government loves documentation. Written policy about, punching in and out, and then you have to actually take disciplinary action when people don't punch in and out properly or don't properly record their own time. But otherwise, you're setting up a sort of precedent of a permissive attitude towards this. If you don't walk the walk and talk as well as talk the talk, you're going to have problems. If you have a policy, and I mentioned this in the handout, if you have policies in writing, follow those policies, or don't put it in writing then, because you're just going to be setting yourself up for trouble down the line. Unpaid breaks and meal times and all that stuff is like a major thing that comes up in a lot of these cases, and applying the right rate of pay. So if they take a break during overtime, that's a paid break, then that break, you might be able, in some states or localities, you might be able to pay it straight time. In other states or localities, you might have to pay it overtime. It varies. There's this whole concept of what's called pyramiding of overtime. I write a lot about it on my website. That's very complicated, and you get into these issues of multiple pay rates based on the different times of day that people work, or based on the number of hours over a week that they work in overtime. And it all depends on the locality, the state, or federal law, whatever applies. In some cases, what applies is a contract. You might be working under a federal contract, like a school contract, that might have its own rules regarding paid time and recording of time and things like that. So then you have this whole other layer of bureaucracy that you have to deal with. And that's problematic in and of itself. So, good question.
At the beginning of your talk, did I hear something about, say the person can punch in 15 minutes before their shift starts, but they punch in 30 minutes before. How do you handle that extra time that because they might be the kid that always forgets to punch in, so they walk in the door, they punch in, instead of having to come back, they're just hanging out. Do you have to pay for when they punch in? Or?
Generally, no. I mean, as long as they're not working. So if they're just hanging out in the place, not working, no. But, the de minimis exception that happens in a lot of these cases is only for a few minutes. So if they're doing any sort of, you have to make sure they're not working, because if they're doing any sort of work, they're doing a favor for their boss or a favor for a coworker, that might be counted as work. And you got to be careful of that type of stuff. And that's where you have to, you have to talk the talk as well as walk the walk. I mean, walk the walk as well as talk the talk. And you got to basically follow through on your policies and practices to make sure that you're consistently enforcing them.
Well, and that did come into play. And 10 years ago, are you going to remember that he didn't work those 15 minutes? All of a sudden, you've got to produce thousands of time cards.
Oh,
the kids.
I wanted to bring up an example in your case, too, because we had depositions. Usually, a lot of these cases, we don't actually get into depositions, but one of the problems I had as being third attorney handling this was that we actually had to have depositions, because that was one of the ways. The depositions were useful to me, but it was also a way for the opposing counsel, and I give him credit for doing this, right? I mean, he was right for doing this, and I give him credit for doing this because the depositions exposed a lot of problems. So we had one of the witnesses testifying about her time, and we were looking at her time records, and it turns out on one day, or more than one day, she clocked in at like 7 in the morning on a Monday and clocked out at 10 in the evening on Friday. Like literally she had like 100 hours and like a pay period. She just forgot to clock out during that whole time. And those are the types of issues that lead to inferences of other problems where, you start getting into, all right, obviously she didn't work 100 hours, but, where do you draw the line?
But isn't that the time when you would write on the time card or whatever, came in early? I mean, shouldn't you just take good
Well,
notes?
you have to then
And sign it, or have them sign it?
have them sign it, exactly. So it's not good enough for you to sign it. You have to call it to their attention and have them to sign it. Anytime you make a change to somebody's time card, payroll, whatever, whether it's the official copy or the stub, whatever, they have to acknowledge, you have to get them to acknowledge, that it's being done, and you have to understand why it's being done. That's why I say maybe, survey your own employees quarterly or whatever, or every 6 months, whatever, and say, hey, are you aware of problems, whatever. It's not a absolute defense, but it's going to help go a long way. And and then also you could also trace back when and where problems arose, because if they're signing these like quarterly or semi-annual statements saying that everything is cool, then at least you could look back and say, okay, so when did this problem start? Did it start before you thought it was we were doing it right in the first half of the year, or did you find out, or did these problems start in the second half of the year when you haven't signed the statement yet?
Well, in the new payroll systems for time clocking, we use Humanity, which is what we were told to use after all of this, is you can lock them out. They cannot clock in more than 5 minutes close to their
That's not ours, is it?
yeah, Humanity is awesome. It does the scheduling. And then my accountants go in, they take the time reports. We don't even deal with them. And then they do the payroll from that. But you can put a lot more parameters than when we use Party Center. I thought it was very convenient because they're already cashiers and stuff, so they would clock in. But Party Center doesn't have any controls to warrant changing, clocking in early, changing your records. It's just not locked down like the new ones are. So Humanity has been very, very good. It's easy to use.
A note about using third-party vendors. And this doesn't matter if you're talking about an accountant or an attorney, a payroll processor, whatever. Do your due diligence on them. Make sure, and what this comes down to is not just like some internet research, but have them, like myself. I think one of the reasons why Sandy and I got along is that I'm able to explain these concepts to her in plain English. If you're hiring somebody that can't explain this stuff to you in plain English, stay away from them. That's why I said at the beginning of this, if I'm not explaining this right to you, or if I'm talking over your head, this is pointless.
I think we got along because you always called me back.
Well, yeah,
I
but
spent
that's
6
the
months
easy
trying
part.
to get an attorney to call me back.
Responsiveness is the easy part, because I hear that from a friend of mine going through a divorce, and his biggest gripe he's on his second attorney right now, and his biggest gripe is that I don't hear enough from them. That's why he got rid of the first attorney, because they don't call back. Well, again, common sense. If somebody calls you, call them back. I mean, I'm not selling you I'm not trying to sell you financial advice and things like that. So I mean, talk to each other and explain this stuff. Every time I'm in court, I always send you a copy of what goes on in court and explain what happened. For whatever reason, I don't know why a lot of other attorneys don't do that. Maybe they don't understand what they're litigating themselves. I don't know. But to me, that's just, again, common sense type stuff. The same type of communication levels I maintain with you is what business owners have to maintain with their employees. You explain this stuff to them in plain English and get them to understand, because if you can't, if they don't understand it, they're going to talk to somebody who they think will understand it, or will, and I could guarantee you that the person they talk to, especially if they're another attorney or from a government agency, is going to put dollar signs in their eyes. It's going to make them see dollar signs. So that's the bigger picture of this. It's not, like I said, it's not rocket science. A lot of it's just common sense, but be diligent on how you handle your payroll and how you do your timekeeping and all that. Don't let issues fester. Don't let things go. Don't be like, oh, that's just Joe complaining. He always complains, so we could just blow this off.
My husband just brought up something. He just had a question for me to make sure we still had it. Speaking of piercing the corporate veil, coming after you personally, how beneficial is it to have a personal umbrella insurance policy? Does that protect you?
It could,
can
potentially.
They get up through that also?
My dad has one.
And it didn't do no good.
Really the policy that's
Federal.
the type of policy the type of policy you probably need is like a rider or separate clause or something like that to an employment practices liability insurance policy. Something that, yeah.
Well, but also
I was talking to John about this last night, actually.
But
John
if
is
it's-
awesome.
But
Yeah.
if it's considered theft, those riders may not
No,
cover.
the rider. If you have a rider that explicitly covers,
It's got the peril in it.
I'm sorry.
If you have a peril in the existing policy, your umbrella will protect you if you exhaust.
So the liability pays
underwriting
for the first,
liability.
liability
First.
pays for the first level,
Right.
So
the
the
umbrella
third
would
degree
pay
of
for as far as the second level. But
Yeah, let's go back.
every policy is different. You gotta look at as far as terms, exclusions, all of those different things. So I mean, to answer your question, you have to take a look at as far as your policy. What Charles is kind of talking about here, there is something called employment practices liability insurance. So that would pay for as far as wrongful termination, sexual harassment. But as far as what he's saying, if it's in regards to the,
Fair Labor Standards Act or any of the wage and hour laws.
I'm not sure on that. You'd have to check as far as the policy. Would your general liability policy that you all have cover that? No, it would not.
Yeah, general directors and officers of commercial liability, even umbrella policies will not, usually don't cover that.
And he's talking about a couple different things. So there's general liability, there's employment practices liability, there's D&O, which he said, which is directors and officers liability. So these are different terminologies that we're talking about here, but your common policy for as far as general liability pays for bodily injury or property damage. None of that has been stated, minus exclusions, obviously. So you would have to get it as far as a different product. I'd have to look into your specific case, if you will, or specific circumstance to let you know. But employment practices liability is a policy that's out there that can, like I said, harassment, wrongful terminations. So.
Thank you. A simple precept about insurance, and you hear this on TV shows, you know, even sitcoms, whatever. Sure. Anything's insurable. All right. So as long as you're willing to pay for the coverage, anything's insurable. So you just got to do your due diligence, do your research, talk to the insurance broker or agent you're using. And like I said, and they're a third party, if a third party agent, person, attorney, accountant, doctor, whatever who you're going to can't explain this to you in plain English or in language that you understand, stay away from them. Don't use them. Any other questions? Any topics you want me to go into on this that you think, this is pretty broad stuff too. And like I said, these laws are labyrinthian, although it's not rocket science. I mean, it sometimes sounds like it is. But
Employee handbooks.
yeah. So I mean, if you're gonna, like I said, if you're gonna put something in writing, like an employee handbook, make sure you follow that, and don't put stuff in there that you don't think you're going to encounter. At a roller rink or hospitality or entertainment type of business, there's a good chance you're going to encounter sexual harassment or discrimination, maybe violence in the workplace, something like that. But you might not, there are other issues. And off the top of my head, I'm at an absence to think of something right now, a good example of that. But there's some issues that you may not reasonably expect to encounter, the word reasonably, and you don't need to include that in a handbook. I've seen handbooks that are 150 pages long, literally 150 pages long, for like a small business of about 10 people. This was for a massage day spa type of business. They had all this stuff about military veterans and uniformed services, employment, reemployment and retraining act, USERA, and all this stuff, but they didn't have any of these people. And we were able, I was doing an audit of this and review, and was able to cut out about 100 pages of it. Even 50 pages was still too long, but at least, as a first go-through, as a first, ferreting out of all the nonsense, you address issues that you could reasonably expect to encounter.
Just go along the same lines with the employee handbook. We pass out an employee handbook, each of our employees. We have a form which they sign that they certify they have received a copy of this. Now, that being said, it says received a copy of it. It has no testimony saying that they have read it or even understood it. Are we in a precarious position because we haven't certified they have read it or understood it? Or are we only required to give them notice, which is in fact we're proving we gave them notice of it by giving them a copy of our employee manual and our policies and procedures?
Generally speaking, there's no law that says you have to even give them notice or have them give you notice, unless it's part of a contract, maybe a government contract. But no, what happens is that, and this is the typical lawyer answers, depends on the circumstances. So let's say you only produce the handbook in English, but half your workforce speaks Spanish and doesn't understand English. That's going to be a problem.
Okay.
If a third of your workforce only speaks Polish, a third speaks Spanish, and a third speaks English, and you only cover Spanish and English, you're going to have a problem. So that's where you have to look at the circumstances and all that. If the handbook has, and I've honestly never seen this, but this is just an example of the time I had, if it contains a plethora of racial epithets, of racist language, and half your workforce is African American and Hispanic, you're going to have problems. All right? So, you know, or if it's written in, you know, if it's written over their heads, like it's written like a technical manual from a nuclear reactor, you're going to have problems. As opposed to like a roller rink where maybe you do have some people who used to work in a nuclear reactor, like a Homer Simpson or something like that, but obviously Homer's not that smart to begin with, so.
Chuck, if you have a policy in your handbook, like we always had, this is how we pay, 15 minutes before till close, and you don't have any clock information because that's your policy, would you still have to have clocking information? Like they have to clock in and clock out, if they know they're going to be paid for that time standard?
Yeah, you might not.
Maybe it would have been better if I never had to clock in and clock out.
Thank you. Possibly. But again, then there's the inference that if they claim that they're working extra time and there's no way for you to know that unless you have maybe cameras showing them leaving and arriving and leaving on time, you know, then you're going to have problems. I mean, yeah. I mean, theoretically, if you have like some sort of camera set up that shows everybody leaving and arriving on time, but no other payroll records.
Even if they sign in?
Does that mean time's up?
But I mean, even if they signed in at 1:45 and they left at 5, you know?
Well, yeah, I mean, if they sign in at 1:45 and the camera shows them leaving at 5, then...
No, but I would say you don't have the camera, but the employee puts their initials down?
Yeah, that's one of the things we had to rise was that, yeah, but if people can testify, if witnesses testify that they actually left at 2:30 as opposed to 1:45, then there's this inference of unrecorded time. And you have a problem then. That's part of what happened was that there were other people testifying, you know, the company says A, but the employees, and more than one employee says B. And that's where you have a problem, is if other people are saying B. And these other people are credible. Their testimony is reasonable, reliable, whatever. You know that it's not, you know, Joe the pathological liar or something like that. Question? Hey, it's time's up.
That's it.
Cool. Thank you. I appreciate the opportunity, and thanks for the questions.
Good job.
Thanks a lot. I'm going to be around, too, so if you have any questions, whatever.
Thank you, Chuck. We're going to take a short 15-minute break. Give you time to take a break and visit the vendors, and we're going to